Are you keeping up with the latest in workplace health and safety in Australia? Psychosocial safety is now more important than ever, with new regulations emphasising the duty of care to prevent psychological harm. Join us on the 29th of August for a rapid-fire webinar hosted by two FlourishDX experts as we tackle these pressing challenges and pave the way for future best practices in psychosocial safety. Gain insights on beyond engagement surveys by learning how to more accurately quantify psychosocial risks. Discover strategies for improving the governance of psychosocial safety. Understand how to provide ongoing monitoring of psychosocial hazards and the effectiveness of controls. And determine the prerequisites for empowering line managers to take ownership of psychosocial safety. This webinar is a must for any health and safety or HR professional dedicated to creating a safer, more productive work environment. Don't miss out on this vital opportunity. Register now to ensure your organisation takes the lead in psychosocial safety. Visit www.flourishdx.com to register. See you there. Now on to this episode.
From FlourishDX, this is the Psych Health and Safety Podcast. With workplace mental health becoming a safety prerogative, this is the source of information on psychological injury prevention and health promotion.
Hi, and welcome to the Psych Health and Safety Podcast. My name is Jason and Joelle, and I'm one of the hosts of the show. The aim of the podcast is to rapidly increase the knowledge and application of psychological health and safety in workplaces worldwide. To help with this, we have regular guests from around the world who are leading the way in this important area. But before I introduce our guest and topic for today, allow me to introduce my co-host, Joelle Mitchell. How are you today, Joelle?
Yeah, okay. Feels like there's just lots going on.
There is a lot. I feel like there's a lot. It's actually my daughter's birthday tomorrow.
Oh.
Yeah, she's turning 12. So, juggling family as well as everything that's going on with work.
Yeah. You doing something nice for her birthday?
Hopefully. Well, I look after the working
I wasn't
family.
asking if you personally had planned something. I was just asking, do you know what you're doing for her birthday?
I know she's got some friends who are staying over for a sleepover. Apart from that, I still think, as of yesterday when I spoke to my wife, it was still undecided what activities they were going to do during the sleepover.
Mm-hmm.
So it might have been like facial masks and I don't know, that sort of thing.
Okay. Yeah.
Like preteen type stuff.
I'm actually glad you're in that bigger house.
Yes. So, yes, can maybe sleep in a different bedroom.
Yeah.
That'd be good. Yeah. Well away from the noise,
So
is what I'm saying.
You won't be kept awake by the giggling all night.
Yeah, that's right. Juggling work and personal life. We just had a webinar this morning that did with Heather.
We did. There was lots of people on that call.
Yeah, so we had a record, right? So within the first 24 hours, we had 400 people register for this webinar. It was on psychosocial investigations, and I think I just had a look, and there was about 500 people that joined us live.
Yeah, wow.
So that's a record for us. So we'll have to keep finding those hot topics that people are craving information on. But the next one will be on the 29th of August. So, hopefully see some more people there. But look, our guest has been patiently waiting. We've got a really interesting topic to talk about today.
We do, yep.
So I should introduce her in.
Yes.
Yeah, so joining us from New Zealand, she's a legal specialist in employment law and health and safety. She represents clients in disputes and advises on risk mitigation. She is a partner in the litigation team at Russell McVeagh in Auckland. Welcome to the podcast, Emma Peterson.
Thanks so much for having me.
No, great to have you on. I was mentioning to you before we started recording that I was unaware of who we were talking about. And then when Joelle told me, it's about that matter in Auckland, I'm like, that's amazing. I'm really looking forward to this conversation. I think it's going to be really interesting.
Yeah, it's a very interesting one and has been getting certainly a lot of commentary and media attention over here. So
terrific.
Well, before we get into the case, can you tell us what podcast you like to listen to?
So I listen to quite a broad range of podcasts, but the one that I'm listening to at the moment, which isn't particularly sort of intellectual or highbrow, but it's a parenting podcast in New Zealand called Untidy. I have 3 small kids, so quite a big part of my life. But the reason I like that is because it's not only about parenting, but it's also, like interesting interviews with guests and topical issues and just like entertaining to listen to and helpful and informative. So it's my current listen that I'm, working through.
Yep. Nice. They don't all have to be highbrow academic types of things. We can listen to things for fun as well.
Yeah, you want a bit of trash mixed up with the highbrow stuff.
I don't know if a parenting podcast classifies as trash.
It's called Untidy.
Yeah, It's entertaining.
The
Yeah.
stretch, Jason. Just arguably, life with kids is untidy.
Yes, this is
Yeah.
true.
Correct, isn't it just?
Sure is. Emma, can you tell us, please, about your professional career?
Sure. So I'm a lawyer. I've always been a lawyer. I started out at the same firm I'm at now, Russell McVeagh, just a few years ago as a sort of law graduate out of university. And I did what most Kiwi lawyers do. I did 3 years in the employment and health and safety team, and then I went overseas traveling and then worked in London and then Hong Kong before coming back to New Zealand. And I came back to the firm in 2016. I've been back ever since. So I sort of fell into employment and health and safety quite fortunately because it's just the job that I got offered as a fresh-faced law graduate. And luckily, I just love it. It's such an interesting area of the law, I think. People are always doing interesting things. Every day is different. It's a good sort of mix of work, interesting work, great clients. Yeah, can't complain.
Yeah, no, we've had some interesting people who practice in this area on the podcast before, like Nerida Jessup from Herbert Smith Freehills, Catherine Dunlop from Maddox. Yeah, so they're quite interesting people, so it must be interesting work. So we wanted to talk to you today specifically about a recent case in the New Zealand Employment Court involving Associate Professor Siouxie Wiles and the University of Auckland. So for those of you who are not familiar with this case, can you give us a brief summary?
Sure. So, for those of us in New Zealand, Associate Professor Siouxie Wiles was a real household name over the COVID pandemic. So she is a microbiologist employed by the University of Auckland and a sort of scientific commentator. So over COVID, she was all over the news, lots of public commentary, always being interviewed about COVID-related matters. And she has very bright pink hair for anyone that hasn't seen a picture of her. So very noticeable and was really great at sort of turning complicated scientific information into easily understandable, digestible content. So she's really popular, especially with the younger audiences. So always on the news and things. And so, yeah, it just became a real household name. So she obviously was highly praised for that. She played a really important role here as part of the pandemic. She won New Zealander of the Year in 2021, so definitely a lot of accolades. But I suppose the counter to that was she also got a huge amount of public abuse and harassment. So we all know COVID was a wild time, lots of really strong, polarizing views from different parts of society. And she really got a lot of quite awful online abuse and harassment. Um, and she basically brought the claim against her employer, the University of Auckland, for what she said were its failings to adequately protect her from those, I guess, psychosocial risks of this kind of public abuse and harassment. She had three sort of key parts to her claim. So a breach of contract, failure to comply with health and safety duties, a breach of statutory good faith, and what we call in New Zealand a personal grievance for unjustified disadvantage because of failure to protect her. So it had a 3-week hearing in the employment court in November, and we just got the decision. And so the court did identify a number of failings by the university. Dr Wiles was awarded $20,000 damages. So, it's not a huge amount of money, but she's been quite public in saying that this was a principled thing for her. There was a lot at stake for her in terms of what she felt was a narrative that needed to be heard.
Yeah, so it made it all the way across the ditch. We heard all about it here. Obviously, there's a lot of people working in academic institutions here in Australia, and we know that psychosocial hazard exposure is a big issue for higher education in particular. But yeah, interesting to hear this case where it wasn't necessarily directly related to what was perhaps in her job description, but some of the things that she was doing as a specialist, as a university representative in essentially what the university deemed was her own time.
That's right. So the university's position was initially that her public commentary was not part of her role for the university and therefore it wasn't work. such that they said initially that they didn't hold the relevant health and safety duties in relation to that work or those actions. By the time it came to a hearing, the university had accepted that it was work and therefore the health and safety duties did apply. But certainly an interesting sort of issue of, well, what kind of activities fall within a job description and what don't. And I think, it's a pretty unique scenario. You've got someone who is a specialist in a specific scientific field working for a university. So it's not going to be that common to have that exact scenario. But I think it is certainly a good thing for employers to think about, well, what actually is work? And if there is something that's sort of outside of the workplace or that seems to fall outside of duties, just making sure they're clear on what actually is and isn't part of the job, and therefore where do their duties lie.
Mhm.
Yeah, there's definitely something, I think, around you're employed by that university as an expert, so is it reasonable to expect that, you would be contacted by members of the media to comment on things and that sort of thing. So, there's definitely some sort of reasonable expectation in there, I think.
And I think that was accepted in the end by everybody.
Yeah, and foreseeable risk, right? This is not unique to that particular university. Every university has specialists who get called upon by media regularly to provide commentary.
Yeah. And I think it was sort of clear in the decision that these types of issues had arisen before in terms of public commentary or responses to public statements. I think it was just that in this particular scenario with the COVID environment, everything was, exacerbated or much more serious.
And I'd imagine similar to other specialists in this area during COVID in Australia, that she would have been on TV pretty much every single day or very, very often.
Yeah, I saw one commentator saying that she did sort of sometimes up to 20 interviews a day and things like that. So definitely out there everywhere. Yeah.
So, can you give us a rough timeline of events from when Dr. Wiles first raised those concerns with the university and sort of what happened after that?
Sure. So she first raised the concerns with the university in around March 2020, so quite early on in the pandemic. Um, and that was because she'd been getting emails and texts from a particular individual basically disagreeing with the advice or the information she was providing publicly, didn't agree with the government's response in New Zealand on COVID, and was quite sort of forward in their views and their disagreement, but that person wasn't actually personally attacking her, so she flagged it to the university. And then from that point onwards, she says that she began receiving what she called low-level harassment at that point. So emails, social media, and particularly from a particular group of people in New Zealand who disagreed with the government's response to COVID. And that just sort of slowly started to increase over time, both in terms of volume, but also in terms of the sort of aggressiveness, I suppose, of the comments and the harassment. There were a couple of particular scenarios which she talked about in her evidence, which were really upsetting to her. So one was a situation of doxing. So her personal details were published online, her phone number, email address, home address, an image of her house. And, there were a number of issues like that. She got approached by a particular group saying that issuing her with what they called a cease and desist order, referring to the Nuremberg trials, and saying she was on the accused Nuremberg list. So just, some comments along those lines, and then just some really horrible threats of violence, sexual violence, really, really awful things just started coming in, name calling. So she was in sort of constant dialogue with the university about those matters. But I think one of the key aspects of the case is that the university sort of acted but didn't act quite quickly enough in terms of putting the protections in place that were required. And so whilst the court said, well, look, the university clearly did take some steps, but the issues were that the steps were too late and actually not sufficient given the seriousness of the threat she was getting, and how high profile she was at the time.
So, what were the steps that the university? Oh, we've got that question later. Never mind.
Oh, you're out of practice here, Joel.
I am. Yeah,
Yeah.
I've couldn't remember what was on the list.
Yeah.
Um,
So it's, I think, my question.
your question. Over to you, Jason.
Thanks, Joelle. Um, so I can imagine myself, but what were, I guess, the documented impacts on Dr. Wiles at that time?
Well, I think, as you say, we can only imagine, but certainly she talks about her physical and mental well-being being significantly impacted. So she found it incredibly stressful. Some of the comments were very distressing. There's not a huge amount of information in the case about like the particulars of her experiences, but I think safe to say that because of the sort of content of the abuse and harassment she was getting, it was extremely stressful for her. And that was over a relatively lengthy period of time.
I'm wondering if during the case, if there were any other kind of relevant examples of, you talked about doxing and, getting death threats and that sort of thing. If there are any other relevant examples of like the impacts of that sort of harassment on people's mental health, if that was shared, if you're familiar with that.
Yeah, I mean, not in this case there weren't, but certainly, in other cases where you there have been similar issues, although again, this is a pretty unique circumstance, but certainly I think it can have really severe impacts on someone's mental health. And I suppose it depends on the person as to how severe those impacts are. And by all accounts, Dr. Wiles actually handled what was an incredibly harrowing situation pretty remarkably well. Not to take away from the stress that it would have caused her, but others might not have quite fared as well as she did. So.
Yeah, I mean, to continue to put herself out there, right, and continue to be the voice to the pandemic.
And she talks about the fact that the harassment has been ongoing and she expects it to continue post the hearing and post the decision being published. And yeah, so she's done quite amazing things, I think, for this country.
So what were the key elements of her claim against the university then?
So as I mentioned at the beginning, so there were sort of three elements. One was a claim of contractual breach, and so for today's purposes, the sort of key aspect of that was breach of health and safety obligations under the particular contract and also an implied term to provide a safe working environment. Then the second was a breach of good faith. So in New Zealand, we have a statutory obligation of good faith where both an employer and employee need to be engaged, be constructive, responsive, and communicative. And she claims that the university had not complied with that, hadn't sufficiently engaged with her. And then the final one was the personal grievance for unjustified disadvantage. And that again was around failing to take sufficiently proactive steps to protect her safety. And in particular, in the sort of early discussions, the university had proposed that she could just sort of step back from the public commentary in order to protect her safety and that might be a solution. And she said that wasn't reasonable because, she was speaking publicly for the good of, I guess, society and her role as an academic, and that just to say, well, you could just stop doing that wasn't the right approach from the university.
Yeah, I mean, something like that then has the potential to kind of lead to moral injury types of consequences as well. If you sort of going, well, yeah, I'm going to stop doing this to protect my safety, but, these people who have been engaging in this behaviour then have won, and I'm actually not doing the things that I feel ethically compelled to do out of fear for the consequences for me, and my employer isn't doing anything to help me with that. That opens up a whole other range of mental health impacts.
So, what steps had the university taken in response to Dr. Wiles' concerns?
Yeah, so as I said, that it was clear that the university had taken some steps, and I think one of the key issues is just the timeframes within which they acted. So we talked about the fact that she first raised these issues with the university in March 2020, and so there was an ongoing dialogue, and there was this issue of considering, well, is it work, is it not, and therefore does the university have obligations, which obviously probably delayed the process a little bit. but it was sort of clear, or she says that the escalation was kind of ongoing and increasing. So in July 2021, so sort of 1 year on, the university engaged an outside security firm to come in and basically do an audit. WorkSafe, our regulator, had input into that audit, and it was broader than just the impact on her, but it was essentially looking at harassment and threats of violence towards academic staff and what appropriate measures were to put in place to keep people safe. They took steps that you would expect an employer to take, like she was offered EAP. They said, well, you could go on paid leave pending the conclusion of the audit if you want. She obviously didn't want to do that. And they offered to quarantine her emails so that she didn't have to see them. So some kind of, I guess, diverting of the emails. But she actually said, no, I want to see them because I want to understand the risk and I want to see if it's escalating so I can sort of look after my own physical safety. They did provide her with other help, like they notified her of high profile events that were happening that could be at risk. They gave her some assistance around sort of social media accounts, other sort of safety things. So there was assistance provided. And then in October 2021, the report got issued, and the university says it then sort of complied with or introduced all of the recommendations. That is disputed. We don't have any detail on the specifics, but Associate Professor Wiles says that didn't happen. And then one of the issues that was raised was that no individual risk assessment had been done. So the audit was sort of more general, and the university did have a process where an academic's safety was monitored and information was sort of collated in a way, and they had a point of contact within the university. So there were systems in place. But one of the issues was that no individual risk assessment had been conducted. So that did happen, but not until mid-2022. So KPMG was engaged to do that. So they did a risk assessment on the basis of her particular circumstances. They had some suggestions around reducing the level of her personal information that was out there, reducing the ability for unknown people to contact her, reducing the information available about where she was on campus, strengthening her security at home, and increasing her own ability to de-escalate threats. So some sort of helpful suggestions there. But again, that's mid-2022. So we're 2 years on from the first, notification to the university. So, the court's findings were that the steps taken, they should get credit for the steps taken. They did try and do things. There's no suggestion that they weren't doing anything, but they were too late and it wasn't sufficient. So if they'd done that earlier, perhaps they would have had more opportunity to sort of introduce some of those measures. The other point was that they hadn't put in place sort of interim mitigation approaches while the audit was being carried on, although obviously they did offer she could go on paid leave. But I think the court's view was that they just should have acted more quickly and essentially done more.
Yeah, I'm not sure how paid leave is going to help very much.
Yeah. Well, I suppose it's similar to saying, well, don't do the communications. It's removing her from the environment, but then she can't do her job. So.
And she's.
Yeah, by that stage, she's in the public. She's in the public realm. Yeah.
Do you need more psych health and safety in your life? Then head over to the Flourish DX Academy for several free on-demand e-learning courses. If you're an internal professional, follow Flourish DX on Eventbrite to register for any of our free fortnightly interactive webinars. Our flagship professional practice program is also exclusively available for internal professionals. The 12-week course blends theory, applied practice, and interaction with other professionals through live lectures and a monthly community of practice session. Find out more about all these learning opportunities or inquire about a bespoke in-house training at the Flourish DX Academy. www.45003.org. Now back to this episode.
So were there you've sort of talked broadly about what the court found in relations to the actions taken. Was there anything sort of specific that was of interest there?
Overall, we've sort of talked about the fact that the court considered not enough was done and too late, and essentially that they just should have moved more quickly. And particularly, the court commented that this kind of harassment of academics wasn't a new phenomenon. Obviously, it was massively increased and much more high risk over COVID, but it had been an issue before. So they were on notice that this was an issue, and so therefore it was foreseeable that this would have been of concern for people in positions like her. The court found that the suggestions that we've talked about around stopping doing the commentary, etc., were not reasonable, and that really she was entitled to have a plan firmly in place, and for that plan to be sufficient to protect her, and that the onus was on the university to kind of manage that and come up with that and get the appropriate expert input and put that in place. So one of the things discussed in the case is that, well, the university was having these discussions with her around how she could be kept safe, but actually that shouldn't have been put onto her. She wasn't a cyber PR, expert. Actually, the university should have been the one getting the input and coming up with the plan. And they did do that to a certain extent sort of later in the piece with the security audit. But I think there's an interesting balance there for employers, because there is a statutory duty to consult about how health and safety matters. So obviously you do need to be having the conversations. You do need to be engaging with people and getting their views, but it's that balance between not just putting the onus back on them and making sure that you as the employer are doing enough to comply with your duties. So I do think that's a sort of something to be alive to. I mean, overall, the court found that yes, the university had breached its contractual obligations to her. It had breached its duties of good faith. It should have engaged with her more constructively, and it had unjustifiably disadvantaged her. But so she was sort of successful on those three key points, albeit that it's a $20,000 award, so and no penalties, so just a damages award which incorporated all of the remedies. But again, I don't think this was ever really about money.
Yeah, and so does that finding then sort of put additional actions back onto the university in terms of its systems of work and that sort of thing?
Well, I think it's not clear from the decision, but it would appear that the suggestions that have previously been provided by the experts have now been implemented, or at least that's the university's position. So I suspect that the factual scenario now that academics are operating in is quite different to what it was in 2020. So I suspect some of that work has been done, but it's certainly something that I imagine the university and probably other employers in similar positions are looking at, just to make sure that they are doing what they need to be doing.
Yeah, so does that kind of set like a legal precedent around what an employer should reasonably be doing from a staff security perspective?
Yeah, I think it's good. It's really good guidance, and that if you are an employer who has people out there making public commentary, and particularly where they're sort of on controversial topics that are likely to result in strong public views, you do really need to be thinking about acting quickly and acting appropriately. Um, you're not going to have time to sort of sit around and do nothing and wait to see if it gets worse. But I think one of the key things from the case that's important is just to put in place sort of interim measures while you figure out what the long-term answer might be, because most employers, academic institutes, whatever the nature of the business is, are not going to be experts on all of these things. Obviously, they're going to need to get information from other sources, but it's about putting in interim measures to make sure that while you have the opportunity to get the information and put a plan in place, you can be ensuring, I suppose, that you're taking steps to protect the person.
Yeah, because it did sound like a lot of their suggestions came from probably a very uninformed place. So, yeah, just based on what they suggested that she do, sounds like they maybe hadn't actually got advice from appropriately competent people to actually sort of inform those recommendations to her.
Yeah, I mean, I think that's right. I think some of that was at the point in time where they may not have had the information they needed, and had they had the information earlier, probably it would have been different. I suppose it's easy with the benefit of hindsight to say, oh, well, clearly that wasn't, a good suggestion. It's difficult. And I think also the fact that, they're in the middle of a pandemic and all of those things, everything's a bit harder. But yeah, I think that the lessons really are act quickly, put in place measures, even if you're still in the process of figuring out what the best approach is long term. Put some measures in place pending that, to make sure that you're doing what you need to be doing.
So, like we've been talking about, this is probably very commonplace in universities, this risk, less so in other organisations. But I guess what are the learnings for both, I guess, academic institutions as well as other employers from this case?
Well, I think there are some sort of overlapping general learnings which will apply to all employers, and then obviously those in the academic world will have more direct effect, or will be more impacted by the findings. But I think even if you're an organisation where you have people speaking publicly, your external comms team or your PR people, or anyone that's sort of out on social media talking about things, that it's a good lesson to just be making sure that those people are appropriately protected, that your cyber protections are appropriate. Obviously, if you've got people out there making public commentary on issues that are controversial, they're going to be more at risk. And some of those measures we've talked about in terms of getting the expert input, putting interim measures in place, are going to be important. And then I think even for employers that don't necessarily have people out commentating in the public sphere, if you've got people doing things sort of outside of the traditional workplace or outside of work, thinking about what is and what isn't work, I think is a good thing as well, just to sort of identify that issue of, well, what is a particular action or activity part of their role. And then just some sort of broader principles that come out of the case that probably are easy to sort of identify in theory, but I think are helpful reminders around making sure you've got appropriate plans and risk assessments in place. So, do the risk assessments where you need to, determine what are the appropriate controls to manage a hazard, whatever the hazard might be, and that's an ongoing process. So it's not just to do a risk assessment once and you're done. Circumstances are evolving. That was particularly the case in COVID, where things were changing every day. But even in the post-COVID world, things are changing. So keeping an eye on risks and hazards for your people, making sure that risk assessments are refreshed, making sure that the way that you respond to hazards adapts appropriately as circumstances change. I think that's really important, because you do need to be proactive in those things, rather than sort of waiting necessarily for people to raise issues, and being alive to what the particular hazards are. And then I suppose my final point is just around that point around consultation with employees. So you've got statutory health and safety consultation obligations. Consultation is an important part of your employer obligations to employees as well, but just finding the right balance between engaging with people appropriately, but making sure that as the employer, you are doing what you need to be doing to comply with your obligations.
Yeah, that's all really good advice. Anything to add to that, Joel?
No.
No? Okay, well, it must be
Very comprehensive.
Very comprehensive. Emma, that's been really interesting unpacking that case with you. Like you say, someone, New Zealander of the Year, had massive influence during the COVID pandemic when people needed, a guiding hand, and, amazing what she was able to put up with, and still putting the public health, above her own health. So good to hear about, how employers, I guess, can do the right thing by those employees who are willing to do things for the common good. So, Emma, I'm assuming you haven't listened to this podcast before, but at this point in every podcast, we like to ask our guests the same question. And that is, if you were to think about the future, what would your hopes for the future of workplace mental health be?
So, I suppose what I would say to that is that I think we have made really good progress in New Zealand, in terms of being able to talk about mental health and removing some of the taboos around it and understanding how it relates to the workplace. But we still have a real mental health sort of issue in New Zealand, and I think there's always more that can be done. When I look at some of our clients and what they're doing, some of them have quite amazing sort of wellbeing and mental health support programs, and I think that the more that that is available in the workplace, the better for mental health. I think New Zealand is in a bit of a sort of transition period at the moment, because so WorkSafe, our regulator, have come out and said that for the short term, they're not going to be focusing on psychosocial risks because they've got a lot of other issues to focus on, and that's because in New Zealand we have a still really high level of workplace fatalities. So whilst there's been a real regulator focus on psychosocial risk up to this point, and I'm sure that will continue to be important, I do think that there's going to be sort of a slightly less, or WorkSafe have said there'll be slightly less focus on it. So I do think there is an important role to play for employers in the workplace. And I think what I'm seeing in my employment practice is that when employees bring a claim, there will often be an element of health and safety in the claim. So a failure to provide a safe workplace, a breach of health and safety obligations. So I think we're finding that come out a lot more in the employment sphere as well, and I think that will only increase. So, I mean, to answer the question, I think the more we can talk about it, the more we can have, good resources and good education for people in the workplace, the better it's going to be for everybody.
Good words of advice.
And do you have any parting words for listeners who are interested in working in the field of workplace mental health?
I mean, I guess it's such a broad field. There are so many ways you can get involved in it. So I think it's figuring out, like, how do you want to be involved? So, you could be a consultant, you could be a lawyer, you could be working for a business and the safety HR team. You could be on a podcast. And so I think it's kind of probably just figuring out how you wanted to be involved in it and talking to people that are in the industry. Like, there's such a wealth of knowledge around, and people doing amazing things in the health and safety space and around psychosocial risks. So probably just education, and then figuring out how you'd like to be involved with that to figure out what the best path is for you.
Yeah, definitely lots of pathways available.
Emma, again, thank you so much for your time today. It's been a fascinating conversation. Thanks for joining us from across the ditch, and hopefully it's not the last time that we have you on. Although, if we have her on again, it's probably because someone's been injured in the line of work. So it's probably not a great thing to have her on again. But interesting conversations when these cases do come up.
Absolutely.
Yeah.
Oh, well, thanks for having me.
So listeners, that brings us to the end of this episode. Remember, when we do have these interviews with our amazing guests, we do record them over video, and you can find those videos on the Flourish DX YouTube page. You can also find snippets from these conversations on the Flourish DX LinkedIn page. And while you're on LinkedIn, you'll be able to find Joelle and myself over there. Feel free to drop into our DMs if you want to have any further conversations about this topic or others related to psych health and safety. But that's it for today. We'll catch you next episode.
You've been listening to the Psych Health and Safety Podcast. To stay up to date with the latest on psychological injury prevention, follow Flourish DX on LinkedIn and subscribe to the Psych Health and Safety Podcast at www.psychealthandsafety.com.